Welcome to The Explainer. Today, we are looking at something absolutely fascinating. It's a legitimate, real-world loophole that lets you completely bypass law school and still become a fully licensed attorney. I know, it sounds almost too good to be true, right? But as we're going to see, it is very real. And, well, it definitely comes with some serious caveats. Okay, let's dive right into this. Can you actually become a lawyer without going to law school? You might instantly think about pop culture icons like Kim Kardashian, who famously took this exact route. Or maybe you're picturing Mike Ross from the TV show Suits. And because of that, it's super easy to just dismiss the whole idea as a Hollywood myth or some kind of celebrity stunt. But the truth is, regular, everyday people do this. They pass the bar and they practice law, literally without ever stepping foot inside a law school lecture hall. The official name for this path is the Law Office Study Program, though traditionally it's just known as reading the law. So instead of sitting in a classroom for 3 years and racking up this absolute mountain of student debt, you study directly under a supervising judge or a practicing attorney for 3 to 4 years. Now, it is an incredible way to avoid 6 figures of debt for sure. But as you can imagine, it requires a staggering, almost unimaginable amount of self-discipline to actually pull off. Now, before you march down to your local law firm and ask for an apprenticeship, you need to know that this loophole is incredibly rare. It is entirely legal to bypass law school, but only in California, Vermont, Virginia, and Washington. Oh, and New York is on the list, but there's a slight exception there. They still require you to complete at least 1 year of traditional law school before you can start reading the law. Everywhere else in the country, you absolutely need that traditional law degree. So, the crucial point is the catch. Because there's always a catch, right? Without a traditional Juris Doctorate, or JD, your career mobility is severely restricted. Each state sets its own strict rules for who can join their bar, and almost all of them require that JD degree. That means if you read the law and passed the bar in Virginia, you can't just pack up and move your practice to Florida or Texas. You are essentially geographically confined to the exact state where you studied.
Section 2. Rules of the Apprenticeship. The grueling realities of skipping school.
Let's move to and see how this builds, because you can't just walk in off the street. Here are California's rigorous step-by-step requirements for their program. First, you need at least 2 years of college or equivalent CLEP exams just to start. Then you have to commit to 4 full years of study, putting in a minimum of 18 hours every single week. Your supervising attorney has to administer a written exam every month. And the real hurdle? Well, in California, you have to pass the notorious first-year law student's examination, commonly called the baby bar, just to get credit for your first year and be allowed to keep going. Now, notice that big number 5. That is the minimum number of hours per week of direct, one-on-one supervision required in California by an attorney with at least 5 years of experience. To give you some contrast, Virginia only requires 3 hours of direct supervision per week. Just think about that for a second. That leaves a massive, massive amount of time where the apprentice is entirely on their own, trying to navigate complex case law in complete isolation. So without professors lecturing you or classmates to study with, how do they actually learn the law? Well, this is the exact real-world survival kit used by a successful Virginia law reader who passed the bar on their first try. They had to totally substitute a traditional classroom with commercial prep courses, things like Barbary and Quimby, just to grasp the basics. They scoured YouTube for specific legal lectures, and for the grueling multiple-choice section of the bar, they used a manuals boot camp, critical pass cards, and BarMax's question bank. They were answering and reviewing over 1,400 practice questions. It's a completely self-taught journey, making use of literally every digital resource available. Section 3. The ultimate trade-off. Pros, cons, and cold hard statistics. A practicing Virginia attorney who actually completed this program summarized it perfectly. They said, "The law reader program is a very lonely path. There is no one to commiserate with." See, while the supervising attorney is busy actually practicing law and working on their clients' cases, the apprentice is usually isolated in a separate office. There's no professor to raise your hand to. There's no study group of peers to bounce ideas off of. When you don't know the answer, you are completely on your own to do the legal research and just figure it out. The emotional toll of that isolation is incredibly real. But you have to contrast that crushing loneliness with this ultimate relief: zero student debt. Traditional law school can cost hundreds of thousands of dollars. By avoiding that debt entirely, these unique attorneys aren't forced into high-stress corporate firm jobs just to pay off their loans. It grants them incredible professional freedom. They can choose to take lower-paid court-appointed cases, they can focus on family law, or work in legal aid. They can genuinely serve their communities from day one without a massive financial cloud hanging over their heads.
And this brilliantly illustrates the risk involved. These are the national statistics, straight from the National Conference of Bar Examiners, between 2014 and 2020. The pass rate for traditional law school students was around 59%, but for law readers, a sobering 33%. Skipping law school makes the actual bar exam significantly harder to pass. The self-guided, isolated nature of the apprenticeship simply doesn't translate to test-taking success at the same rate as going to a dedicated academic institution.
And honestly, if we look at state-specific numbers, it gets even more daunting. In Virginia, during that exact same time frame, traditional students passed at a 69% rate. The law readers? Only 22%. To put that into perspective, that means nearly 8 out of 10 apprentices who poured 3 to 4 grueling years of their lives into this independent study ultimately failed the Virginia bar exam.
So we really have to objectively balance the scales here. On the one hand, the pros are undeniably massive. Graduating with 0 student debt, getting actual real-world law office experience for years before even taking the bar, and having the financial freedom to pursue community service or lower-paying legal work right out the gate. But the cons? They are incredibly heavy. You won't have a JD degree, which a lot of law firms strictly require just to get hired. You're geographically trapped in your home state. You're going to face severe academic isolation. And statistically, you are looking at a 22 to 33% chance of actually passing the bar.
Which brings us to our final thought for this explainer. The law school loophole definitely exists, but it demands an entirely different type of tuition, one that's paid in discipline, isolation, and just pure grit. So, is the financial freedom of dodging law school debt actually worth the grueling isolation and those daunting statistical odds of becoming a lawyer? If you lived in one of these 4 states, do you think you'd have this self-discipline to survive the loophole? Think about it. Thanks so much for joining me on this deep dive, and keep learning.